No, probably one for Daniel is on the composite where the tribunal was held. Isn't there case law to state that procedure in non-compliance is not fatal? Because you're saying the wording is shall and it must be complied strictly. However, isn't there case law to state that procedure non-compliance, if it's not, it doesn't affect the result? Sorry, I lost my train of thought.
I think what you're trying to say is
yeah.
that a ruling of tribunal cannot be thrown out purely for procedural
Yes.
issue.
Yes, thank you, Daniel.
Yes, there is case law, but to in the deepest respect, sir, there's case law both ways. What we would, from our perspective and to advance our client's case, we're very certain that if rules, especially mandatory rules, are not adhered to, there can be no clarity for athletes as well as the fans. And in most of those cases where the procedural issue was not considered pertinent or not considered fatal, it was because there were pre-existing conditions that justified the actions taken. In this case, despite the riots, which only lasted for 3 days, there was no justification for ignoring the mandatory language in the rules. I hope I've answered your question, sir.
Yes, thank you, Daniel.
Thank you very much for your time, panel, Mr. President. That is the end of my submission.
Thank you, Daniel. Can we have the respondents, please?
Members of the panel, before I begin, can I confirm that I am visible and audible?
Yes, but very small.
Would you like me to increase my size on the screen, Mr.
Yes,
President?
please.
Sure thing.
Yes. Yes.
Is this better,
Slightly
Mr. President?
better. Slightly better.
Okay. Thank you, Mr. President. Good afternoon, members of the panel. My name is Seah, and I'll be speaking on behalf of the Respondent, the Games Disciplinary Committee, henceforth the GDC, on the first issue regarding GDC's quorum and a fourth issue on doping, which are Mr. Lander's issues on appeal for 14 minutes. My co-counsel, Mr. Brandon Zhang, will be speaking on issue 2 on the location of the tribunal and issue 3 on Ms. Tang's ability to participate in the qualifying games, addressing Ms. Tang's issues on appeal for 15 minutes. We respectfully reserve 1 minute for our rebuttal. Members of the panel, this case is not about sympathy for one athlete or the popularity of another. Rather, it is about upholding the rules and integrity of the qualifying games. The GDC acted within its mandate, applying the governing rules and principles to protect fair competition and ensured that the games are conducted without illegality or undue advantage. With that, I make 2 submissions regarding Mr. Lander's claims. Firstly, the GDC's quorum was not biased in coming to a decision, as both Ms. Farina and Mr. Douglas are independent and impartial arbitrators. Secondly, the GDC did not err in finding that Mr. Lander has been liable for doping. Bluebat, in its nature, is a performance-enhancing drug. Turning to issue 1, while counsel for the appellant may seek to rely on Rule 33 of the CAS Code, this is wrong. If I could first turn the panel's attention to para 37 of the record. If the panel is with me, what Mr. Lander intends to do is to challenge an arbitrator, namely both Ms. Farina and Mr. Douglas. To determine if an arbitrator should be challenged, the applicable rule should be Rule 34 of the CAS Code. Rule 34 reads, and I quote, "An arbitrator may be challenged if the circumstances give rise to legitimate doubts over his or her independence or impartiality. This threshold of legitimate doubt is similarly noted in Article 180 Part 1c of the Swedish Federal Act on Private International Law, which states, and I quote, "An arbitrator may be challenged if circumstances exist that give rise to justifiable doubts as to his independence." And last but most crucially, the threshold of justifiable doubt can be found in exact wording in the Malaysian Arbitration Act at Section 14.3 Part A, which states, and I quote, "An arbitrator may be challenged only if the circumstances give rise to justifiable doubts as to the arbitrator's impartiality or independence." This demonstrates that the evidence of biasness must be justifiable and concrete, and the threshold has been applied stringently in related cases. The high threshold of justifiable doubt has been illustrated in a 2020 Swiss Federal Tribunal case of Zhang and World Anti-Doping Agency. I note that the counsel for the appellant has raised the threshold of apparent bias, and this was precisely what was addressed in this case. But however, most crucially, they caveated that there must be concrete facts objectively giving rise to a lack of independence, and that is not present in our current case. If I could first turn the panel's attention to para 4 of the record. Ms. Farina is described merely as Ms. Tang's cousin sister. While this indicates a blood relation, as noted by Mr. Ehrman earlier, it is a relatively distant one, and there is no evidence in the record that suggests any meaningful personal or emotional closeness between them. The absence of any frequent interaction, shared household, or personal involvement beyond a single genealogical link supports the inference that their relationship is nominal rather than substantive. Moreover, although the record in para 4 mentions that Ms. Farina had possibly provided some on-the-side coaching, nowhere in the record does it state that Ms. Farina had actually answered the call to Ms. Tang's, and this is where the counsel for appellant has erred in alleging that there was actually a coaching relationship. And furthermore, even if we agree with counsel for the appellant that coaching did take place, this should be viewed as a limited and informal engagement. There is no suggestion that she held a permanent coaching position or received remuneration, and such ad hoc or casual assistance, perhaps in the form of general sporting advice or occasional tips, does not amount to an entrenched professional association that will compromise Ms. Farina's ability to be impartial. It is plausible that Ms. Farina's impossible involvement was situational, incidental, and peripheral to Ms. Tang's competitive endeavors. With regards to Mr. Douglas, if I could then turn the panel's attention to para 26 of the record. If the panel is with me, the professional interactions such as the fan meetups, where both Mr. Douglas and Ms. Tang were spotted together, are typical of public figures in the esports realm and do not indicate a privileged or adversarial relationship that will compromise his judicial capacity. The one-time personal and sharing session which the appellant has sought to rely on was an event that took place 6 months ago. And crucially, the personal sharing session was for, and I quote, the Ms. Tang's team. It was not solely for Ms. Tang's, which does not show a privileged connection. A single historical event, even if it led to them remaining in contact since, does not establish an ongoing dependent personal relationship that will necessarily sway his judgment regarding the complex legal issues of doping or eligibility. There is also no evidence on the record to show the frequency of their contact, as conceded by the counsel for the appellant in his answer to Mr. Ehrman. And getting closer here is only subjective at best. Secondly, even if there was a finding of a relationship, there must be ongoing economic ties or ties that have ended recently to demonstrate a lack of independence or impartiality, and this is noted in the 2015 case of AVB heard in the Federal Supreme Court of Switzerland. In our case, there's clearly no economic ties between Ms. Farina and Ms. Tang, as they are merely distant family members in which Ms. Farina had acted only in a possible capacity of a coach. With respect to Mr. Douglas, there's only a coaching relationship as well, as seen for para 26. And while their relationship that did eventually get closer, there's still no evidence of any economic ties of which Mr. Douglas would have had profited in favor of ruling in Ms. Tang's. And therefore, the GDC submits that a quorum was not biased in coming to a decision and its decisions should be upheld. Unless I may be of further assistance on the first issue.
Don't you think a familiar, a cousin is a close enough relationship to move a panel on the requirement of apparent bias?
Certainly, Mr. President. Understand that the threshold of apparent bias, as noted by the Counsel for the Appellant, is a relatively low one. But as emphasized in the 2020 case of Sanya and World Anti-Doping Agency, there must be concrete facts. And as noted by Mr. President earlier, I believe you asked Counsel for the Appellant regarding what kind of relationships would possibly cross the threshold and that she was only merely a cousin. And we completely agree with you on that point. She is only merely a cousin and there's no facts on the record to show the possible closeness aside from a possible inference of the facts, which is at best only an inference.
Nick?
Yeah. I understand you're coming from the point of view that there's no biasness, but I understand from the appellant that they are stating that there was no disclosure of the relationship. So how do you reply that, or how do you convince us that we should take the view of biasness instead of disclosure?
Certainly, Mr. Erman, I will address your issues on disclosure. Actually, a lack of disclosure does not always amount to a finding of impartiality or independence. As noted in the 2021 case of A International Federation, the challenge arbitrator had regularly failed to disclose information regarding past cases where he served as an arbitrator. While his actions were found to be inappropriate and contrary to the practice of an arbitrator, they found that there was no deliberate intent by the arbitrator to conceal his information, and in our case, there is no deliberate attempt by either Mr. Douglas or Ms. Farina to conceal their prior relationships. If I could first turn Mr. Erman to para 27 of the facts. Crucially, Ms. Farina's reason for the lack of disclosure was because she had figured that their relationship was public, suggesting an absence of intent to hide the association. And with regards to Mr. Douglas, he was previously an online streamer and had been on occasion seen with Ms. Tang's in fan meetups, as seen at para 26 of the record. Given their initial connections were already in the public domain, the notion that either party maliciously tried to conceal their background relationships is undetermined, and therefore a lack of disclosure in our case does not amount to a finding of lack of independence or impartiality. Unless I may be of further assistance on the first issue, I'll turn to the fourth issue on doping. Our submission is structured into two main arguments. Firstly, the GDC acted within its jurisdiction in finding that Mr. Landert had committed a doping violation under Rule 12 of the qualifying game rules. And secondly, the GDC's decision was consistent with CAS jurisprudence and lacked Sportivia principles. As noted in Rule 12 of the qualifying game rules, Rule 12 defines a prohibited substance as any substance or method contrary to the spirit of the sport. While counsel for the appellant has alleged that this is a broad rule, this has actually been defined in the WADA Code at page 13. If I may provide the panel the definition, the spirit of the sport is a celebration of the human spirit, body, and mind. It is the essence of Olympism and reflected in the values we find through sport, through the value of excellence in performance, and excellence in performance is precisely what we are contending here. Putting this in the context of Quidot, it is essentially an e-sport where concentration and focus is the key to winning. This is something that Mr. Landert knows very well, with himself coming in clutch in draw-breaking games as seen at para 6 of the record. If I could then turn the panel's attention to para 12 of the record. In the final match between Mr. Landert and Ms. Tang's, their close draw-breaking game is extremely tiring on the eyes and mind. Therefore, the player who deserves to win it is the one who is able to, without any doping or assistance, focus all the way to the end. However, Mr. Landert was only able to win with the assistance of Blue Bet. Critically, if I could still keep the panel's attention at para 12 of the record, Mr. Landert, knowing that Blue Bet could keep his energy up, kept the drink nearby. Ms. Tangs, with her dominant performance, as seen from para 11 of the record, was bound to have won the tournament if not for Mr. Landert's intervention with 5 points. This concentration-enhancing drug had allowed Mr. Landert to take the edge over Ms. Tangs, as seen from para 13 of the record. Therefore, his actions goes against the core of rewarding a player's excellence in performance, which is against the spirit of the sport. Notably, the counsel for the appellant has also alleged that there needs to be a causal link. Looking at the facts, what is the key difference between Mr. Landert's performance and Ms. Tang's performance? It is Blue Bet. Both of them are equally skilled players at Quidor, and even so, in the final rounds of the qualifying games, Ms. Tangs was unable to keep her focus despite all the effort she put in. And if Mr. Landert has the same ability as her, with himself coming in clutch in the draw-breaking games, it could be said that he will also possess the same level of tiredness in the finals of the qualifying games. And crucially, what is the determining difference? Blue Bet. Blue Bet was what gave Mr. Landert the final edge that allowed him to win the game. Furthermore, Rule 13 of the qualifying games instructs that athletes are to refer to the WADA prohibited list, but the term refer signifies guidance rather than exclusion. It does not preclude the Commission's authority under Rule 12, and nowhere does it state in Rule 13 that the Commission cannot refer to Rule 12. Members of the panel, I note that my time has elapsed. If I may have 1 minute to quickly wrap up my submissions.
Well, 1 minute.
Thank you, Mr. President. CAS jurisprudence has supported dynamic interpretation of the WADA Code. In the 2004 CAS case of Maria Louise Kelly Williams, the tribunal had accepted an unlisted substance could still fall within the scope of the code if it had exhibited similar phonological effects. And in our case, it is clear that Blue Bet has enhanced Mr. Landert and allowed him to take the win in the finals of the qualifying game rules. Unless I may be of further assistance to the panel on the last issue.
Thanks.
Can
Can we have your co-counsel?
Certainly, Mr. President. I'll now hand over my time to my co-counsel, Mr. Brendan Zhang, who will address the remaining 2 issues on appeal. Thank you.
Thank you.
Good morning, panel. Can I confirm that you can see and hear me clearly?
Yes, but you're a bit soft.
Try it.
Is this better now, Mr. President?
Slightly better, yes.
Okay, I will.
Panel members, can you hear the co-counsel?
Yes, can hear.
Okay, proceed.
Good morning, members of the panel. My name is Brandon Zhang, appearing for the Respondent, the game's disciplinary commission. I will be speaking for 15 minutes. We submit that the GDC did not err in allowing the tribunal to be set up in South Nankaland, and that the GDC did not err in deciding that Ms. Tangs is ineligible to participate in the qualifying games. Turning to the first submission, we submit that the tribunal was lawfully chosen for 2 reasons. 1, it was reasonably practicable, and 2, there was no procedural unfairness. If I may direct the panel's attention to paragraph 25 of the record. A day after the tournament, there were massive riots against the government. The riots subsided after 3 days. And pursuant to Rule 23, Sub-Rule 2, the tribunal shall be set up within a week from the end of the tournament in the country where the tournament was held, where reasonably practicable to do so. In the present case, clarification number 22 states that the massive riots took place in Rabutana. And given the circumstances of the case, it was a matter of safety to leave the country as soon as possible. and this was reasonably practicable according to the Rule 23 Sub-Rule 2, because it was not known how long the riots would last, and more importantly, whether the protesters would start another riot within the same week. And at paragraph 29 of the record, it states that the hearing was held in the Global Games headquarters in South Nyasaland, which, by the way, is also an Oceania country. And we submit that merely because it was where the Global Games headquarters was located, that does not mean that there was any impartiality or unfairness. It was chosen because it was the most convenient place at the time to hear the dispute. The third parties in the dispute included the relevant parties, the qualifying games medical team, the Games Committee, and the International Video Games Federation. It was, given the circumstances, practicable to set up a timely tribunal where all the relevant parties could submit their information and evidence. And therefore, it would be appropriate given the situation. And moreover, South Nyasaland is an Oceania country. Ms. Tangs was born in an Oceania country and holds presumably a citizenship in Oceania country. And according to clarification number 16, when parties disagree on the location of the tribunal, the GDC will have the final say in determining the location. And therefore, the GDC was within its rights to hold the dispute in South Nyasaland. And according to clarification 20, evidence was formally submitted. And clarification 21, the parties were informed of the location of the GDC hearing. And in the case, even if there was procedural unfairness, the court may still decide to proceed on the merits of the case regardless, because in the 2004 CAS case of B versus IWF at paragraph 43, the panel noted Rule 57 of the CAS Code gives the panel the full power to review the facts and the law, and the panel has the power to not only decide whether the disciplinary body being challenged was lawful or not, but also to issue an independent decision based on the rules. In the present case, if the panel does find procedural unfairness, nevertheless, the panel can proceed and adjudicate on the merits of the case today. And therefore, the location was validly chosen and reasonably practicable in accordance with Rule 23, Sub-Rule 2. Accordingly, we pray that prayer be dismissed and the GDC's decision be upheld. If there are questions, I will move to the second submission.
Panel members, do you have any questions? Please proceed, panel.
Thank you, Mr. President. Turning to the second submission, we submit that the GDC did not err in deciding Ms. Tangs is ineligible to participate. Under Rule 3, Sub-Rule 1, a person is eligible to participate if he or she is a citizen or permanent resident of a country in Asia. And the CAS jurisprudence has held that rules must be interpreted as to discern the true intention of the rule maker. For instance, in the 2013 CAS case, GNK Dynamo versus UEFA at paragraph 9.11, the court held that the rules must be applied to interpret the rules in question in keeping with the perceived intention of the rule maker and not in a way that frustrates it. In the present case, the GDC correctly applied Rule 3. The intention of Rule 3 is merely of the qualifying games to give opportunities of participation to Asian athletes and permanent residents. And the appellant argues that it should extend to dual citizenship holders. And we argue that the appellant is asking the panel to insert and rewrite the rules of the qualifying games, which it should not do so. And if I may direct the panel to paragraph 33B of the record, the GDC gave its decision and found Ms. Tang's being of dual citizenship ineligible to participate, as she was not 100% Asian citizen. And we do agree there may be some merits in the appellant's case here. However, it was the sole intention of the qualifying games to give the opportunities to a local Asian athlete to participate who had 100% Asian citizen. And
Okay, Brandon, just a moment before you proceed. Are you saying that people with dual nationalities are not 100%? So are they half and half, or is that what you're saying? That means just because she's holding a dual nationality, she's not Asian, or she's not a citizen of that country?
yes, we say and we argue that because she holds dual nationality, this dilutes the rule. Essentially, she holds two nationalities and could be said to represent or have alliances to both countries. And the GDC's position is merely that it wants full representation. It wants to give the opportunity to participate to an Asian athlete who's 100%.
Where do you find that 100% Asian, that intention? Where are you interpreting it?
We are
from?
interpreting it at paragraph 33B of the record in the GDC's decision, and this is in supportive of Rule 3 when interpreted as the true intention of the disciplinary committee in accordance with the CAS panel's ruling on the rules of interpretation, giving true purpose and discerning the true intention of the organizations.
Okay, thank you.
Thank you, Mr. Arbitrator. And now I will turn to the second point. In addition, we submit Ms. Tang's had no close, genuine connection with the country of Doriana. In the 1999 CAS advisory opinion of International Baseball Association at paragraph 27, the panel said a person may have two or more legal nationalities, but every athlete can only have one sporting nationality. And this can be said to be the genuine allegiance of an athlete to the country. In the CAS 2000 case of Mr. Angel Perez versus the IOC at paragraph 17 through 20, the court cited the Notenbaum case. And in that case, the court held there was no genuine prior link with Liechtenstein, and the sole object of his naturalization was to enable him to acquire the status of a neutral national. And the court held that even though Mr. Notenbaum had legal nationality, that it was inadmissible for the claim at hand. And in the present case, we submit that Ms. Tang's does not have a genuine sporting nationality, even though she may hold an Asian citizenship, as she recently moved to the country. And this is reflected at paragraph 32 of the record. And it states that because she moved there, she could not have established a genuine connection. And on the record, we note that any time prior having spent in the country, as indicated by the Mr. Perez case, would not constitute a genuine connection because she left the country and then moved back merely to engage what is called nation shopping to benefit her in her gaming and streaming activities.
Sorry.
I have a
Brandon.
question.
Yes, Jessie.
And if I refer you to this paragraph 32 of the document, it says that she has already domiciled in the country for over 9 years. So why can you justify if a person, because you said that's a like nationality shopping thing, and how you justify that by a person by living in the country for over 9 years, she came to that country only for the purpose of sporting, only for the sporting purpose. That is my question. Thank you.
Thank you, Madam Arbitrator. I will address your question. The CAS panel has held that any prior time spent in the country does not automatically mean that it establishes a genuine connection. And for example, in the CAS case of 2007, Melanie Rinaldi versus Fina, at paragraph 36, the court held that there had to be a real change which corresponds to the center of the athlete's activity, including in everyday life for a significant period of time. And at paragraph 36, at paragraph 11, the panel actually observed that Melanie had resided in that country with her grandmother, aunts, for well over a significant many period of years. But because she had left the country and then returned merely for the purpose of engaging in sport activity, that it was held that she did not, that the time spent prior did not effectively establish a genuine connection, simply because she had left and rejoined to inter-sports competition, which constitutes nation shopping in what it's called. And I know my time. Does this answer your question, Madam Arbitrator?
Yes, thank you.
And on the last point, Ms. Tangs does not have an absolute right to participation in the 2022 Football Union of Russia versus European Footballers Association. At paragraph 134, the panel held that no competitors have an absolute right to participate when the right of participation must give way to other interests, such as another member's right to participate. In the present case, by her participating is not an absolute right. And this concludes my submissions. Thank you. Unless I may be of further assistance in any questions.
Panel members, do you have any questions? Can we have the rebuttal by the appellants?
Thank you, Mr. President.
Thank you, Mr. President and members of the panel. I will begin my rebuttal now. I will first address the first speaker, in which he brought up the case of Sun Yang. Now, we should recognize that in this specific case, it was a very specific case in the sense that, I'm sorry, one second. Okay, it was a very specific case in the sense that there was a very apparent sign of bias. There were online comments made by one of the arbitrators, specifically racist comments. And while a good case, it is an extreme example. Now, if we were to look at the Purchaston case, it confirms that impartiality can also be undermined by structural flaws, lack of transparent appointment procedures, or undisclosed relationships. Again, I think that's my point. I'll move on because there's quite a bit to cover. The first speaker also spoke about the spirit of the sport meant to catch substances specifically similar to those listed, but has not yet had time to be listed. And to be clear that these lists are updated from time to time, and the spirit of sport is meant to be able to catch new drugs, right, that mimic the ones on the list. However, they haven't addressed our point that the various bodies were clearly aware that blue blood, that they have certified or they have taken, their perception was that blue blood was an enhancer, but they failed to include it in any of their lists. Again, I go back to the previous argument made by my first counsel, Mrs. Zahir, that their failure to include it in the list is an issue, and as addressed earlier, it doesn't stand up. The application of the case that you're mentioning specifically, or the interpretation of... Yes, sir.
Daniel.
Yes, sir.
Don't you agree that the spirit of the sport refers to fair play? And
Yes, sir.
fair play refers to not giving one side an unfair advantage of the other,
Yes, sir.
right? So how do you explain that?
Well, I go back to the our first speaker, Zahir, when he made the point specifically that although he did consume blue blood, the case law is clear that, one second, sorry, having a bit of technical difficulties.
Yeah, 4 minutes. Taking 4 difficulties to 1.
Yep. Yes. We still make the case for legal certainty. That is the point at which we're driving home, and it requires that rules applicable to, in the CAS Bulletin 2014-2, that rules applicable to disciplinary infractions must be published, clear, and known to the athlete at the time of the alleged misconduct. Now, the responsible bodies were aware and they failed to inform, and therefore the athlete cannot be held to have erred when he was not aware.
Okay, continue.
Okay, thank you very much, Mr. President. Moving along, moving to the second speaker,
No, they have,
he makes
they
the
have 4
point
minutes.
earlier about reasonably practicable as the reason that because of the riots that they moved the location. As in our initial submission, the respondents are suggesting that in hindsight, they know that the riots did not reoccur, and to be safe, they actually made the choice to move the location. Following that reasoning, that line of reasoning, we would be constantly worried about things that we can't predict happening. And that's not sufficient justification and does not lend itself to the reasonably practicable.
Massive riots, bro. What do you mean?
Next, about the citizenship,
Okay, I get it.
they brought up 3-1. There is an interesting contradiction here that I want to point out. It states that either a citizen or a permanent resident. Now, if I am, for example, a permanent resident of Singapore, I would then naturally not be a citizen and would have to be a citizen of another country. So unless the argument that my learned friends are making is that the sports person in question is stateless, the very wording of the rule implies that dual nationality is accepted. Right. I will just move on now to the couple of cases mentioned by the second speaker, speaking specifically about
I'm just
being
gonna
really Asian,
question
purely
for 1
Asian,
minute.
100% Asian. I will also, before that, I would like to point out that 9 years is not recent, and I don't think that has been proved. I don't think anyone or the common person would take that as recent. Now, in my earlier submission, I pointed out 4 points. I'm going to go through them very quickly in the interest of time. Substantial domicile, I think we've covered. They said that she has no real connection to Durina, but she has always represented Durina in tournaments and has never represented Kyrgyzstan. She's also a local favorite, has close family ties, close ties with the Quiddock community, and is a very popular online personality with Asian fans. All of this goes directly against the cases that were cited by the second speaker. I think that makes my point there. Thank you very much, Mr. President. That would be the end of my rebuttal. And thank you very much, arbitrators on the panel.
Thank you, Daniel. Can we have the Sir rebuttal for the respondent?
Certainly, Mr. President. Before I begin, can I confirm that I am audible and visible?
Yes, you are.
Okay. Thank you, Mr. President. I know that I have 1 minute and I'll be brief. Earlier, the counsel for the appellant has said that Sanya wouldn't be a persuasive case, but the principles are still extremely relevant to what we're dealing with here. And instead, they cited Mutu Peshtin, which is crucially a European Court of Human Rights case, which respectfully bears lesser significance as compared to a Swiss Federal Tribunal case, as this case seat is in Switzerland. And as noted by Mr. President earlier, it's crucial that fair play is enforced. And the only way to do so is to ensure that the WADA code remains progressive and adaptable. And this is noted in the 1995 CAS case of USA Shooting and Quigley, where the tribunal acknowledged that the purpose of doping control is to safeguard the spirit of sport and fair competition, and the panel had upheld the ethical and policy legitimacy of anti-doping regulation, and GDC's actions fall squarely within that legitimacy to ensure that fair play is upheld by including such a catch-all clause. Unless I may be of further assistance to the panel.
Austin, right?
Yes, Mr.
The case you quoted, does it involve a substance that was not listed?
No, it did not, but I can provide you a case where the substance was in fact not listed and they still found a doping violation.
That means you have a case.
I do have a case.
Okay, thank you.
Unless I may be of further assistance to the panel.
That's all, yeah. Jesse, do you have any questions?
Thank you, Mr. Thank you, Mr. President. Unless this concludes my submissions. Thank you.
Thanks, Austin.